Be quiet.
Shh, I'm a Lambo. Greetings, greetings, greetings. It is I, King Clifford Jefferson, ascended of Godfrey, the fifth kind of Andrew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edward the Peaceful, which we know here at the Third Temple English Church of England as the Vicar of Christ, or what we call Melchizedek, or the King of Righteousness. It is October 20th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of my Queen Sister Galveston from the House of Galveston, as well as Archbishop Belmont from the House of Belmont. I greet you in the name of all saints, martyrs, heirs, successors, and all those who are trying to get understanding of what it is that we are here and called to do. It's a beautiful evening. Had my rest, took a nap. What better time is it for me to sit down and break bread with my people, my family? It's very important for you to understand that this lesson is going to be relayed to you today is 756 years are information that you have not been told pertaining to these lands here on these shores. All right, 756. I think it's probably more than that. Let me just make sure. 765 years of information you have not been told. So once again, today you're going to hear and be able to retrace 756 years of your history that has not been told to you here on this land. Okay? Here on this land. And as a result of that, you're going to be able to disqualify all the stories that you were told about this land by seeing your history on this land from the present to the past. Okay? This lesson is called Basic for the Privacy Rights of the Anglo-Saxon Berbers. And this is what the law says. Once again, Basics for Privacy Rights as Anglo-Saxon Berbers, says the law. And one thing you or our people should understand about the law is that we have the right to privacy. And when I say privacy, privacy comes in four forms, all right, in the eyes of law. Either the Fourth Amendment of the United States Constitution or in New Jersey, it's the Seventh Amendment of our state. And every state is different, but within those clauses, you have the right to what we call right of seclusion, the right from intrusion of seclusion. Then you have what they call the right for non-appropriation of name and likeness. Then you have what they call being put in the eyes of the public in a false light, as well as your private lives being used for public commerce. All right, those are the four qualifications for invasion of privacy, i.e., what we call a privacy right. And 9 times out of 10, 99% of all of you who I'm speaking to tonight, as well as those who are not going to be listening, privacy rights have been invaded. A lot of you privacy rights have been invaded, and a lot of you don't know why or don't know how, as a result of you don't know or understanding privacy law. Okay? So today's going to be a good lesson. I'm going to say and take my time and explain it to you that there's 756 years a history that you have not been told about yourselves pertaining to being on this land. And as a result of that, your privacy has been invaded. So please pay very close attention for all those who are going to be viewing this podcast because it's packed with information. Okay? I'm pretty sure all those who have viewed this channel by now know who Edward the First is. You know who Edward the First is. All right? So you first must understand that if you're going to understand this lesson. You have to know who Edward the First is. Let's see, where do I want to start? Let's start with the public record. How important is the public record? Everyone has a public record in their state. All right? Public record is very important, especially for a citizen. If you are a citizen, the public record is very important. All right? And I'm going to use myself as an example, as your king. My people are without a king. And we told that a king was going to come, some type of Lord, some type of savior. So therefore, I fit that description because our people cannot be without their leader. And most of our people have been misled because they don't have a proper leader. They have leaders, but not a proper leader. And this is what is going to be brought to you in regards to understanding how our privacy rights has been invaded. Okay, our privacy rights has been invaded as a result of how those who claim to protect our privacy how have put us up or put us out in the public light as something that we're not. Okay, they have placed us in the public as if we're something that we're claiming to be. We're not something that we're claiming to be. I can't speak for everybody else, but we here at the English Third Temple Church of England are known as the Anglo Saxon Berbers, better known as the English people. Now, this is important. Why is this important? Because right now, our situation here in North America is a result of us not having a leader or not choosing a leader that's able to lead. That's the problem we're in. Okay, so we have to look at the situation, examine the problem, bring forth a solution, and implement it. This is what I have done as your leader. I don't think no one else has took the time to do such a thing. And the reason why I say that is I'm going to go to the example that I set as a leader. This is the pre-indictment, or what I say pro-indictment arraignment. Pro-indictment arraignment, which assumed that the state has indicted me, or assume that the state has received okay from the grand jury. This is why you have what they call a pre-indictment arraignment. This pre-indictment arraignment is governed by Rule 3:912, Section 12 or dash 12 of the New Jersey Court Rule. All right, so when you look at that rule, there's a rule that they have in there called Rule 310:2-D and E. This rule allows for certain motions to be brought forth before trial. And this motion that can be brought forth before trial is a motion for lack of jurisdiction based upon an unconstitutional statute. Okay? The only motion that can be brought forth or based upon the defense or the objection is that of a lack of jurisdiction or unconstitutional statute. All right, these are only one that can be raised at this time in lieu of what we call a pro-indictment arraignment. All right, let me blow this up for you guys. Everybody can see it. I promise to make sure that I keep everybody in the loop of what's going on with our movement. All right. No one else is doing this. I'm keeping you in line and keeping you in step every move of the way. Every move I make in the courts, my people are gonna know. I don't see nobody who represents the people in the courts doing something on the level that we here at the English Third Temple Church of England are doing. Right? It's fine. It's fine. Pre-indictment arraignment, State of New Jersey versus King Clifford Jefferson, November 16, 2024. We're just going to zoom through this right quick. It is November 16th that the King Clifford Jefferson submits this motion before this court for dismissal of the above complaint and indictment pursuant to Rule 3:10 D and E, Section D and E. And as I said, Section D is based upon an unconstitutional statute, and Section E results in a lack of jurisdiction, which are the grounds for a motion to dismissal in a pre-indictment arraignment or a pro-indictment arraignment based upon the rules governing the courts in New Jersey. All right, I don't know about no other court in any other state, but pertaining to the court in which this matter is being heard, these are the rules that I'm using for dismissal based upon what we call something that they seem that's offensive, but yet justifiable. Okay, once again, something that the state of New Jersey seems that is an offense. All right, and we know offense is a violation of law, and the only reason why they see it as offense as a result of the laws that allow me to act in a public capacity in which I act, and as a result of that, it becomes offensive to them in lieu of their criminal statute. But the criminal statute also entails a remedy for justification for my actions in regards to the public office and the capacity which calls upon me to act in my public capacity in my public office based upon a law that was implemented. Okay, which we're going to show you. Okay. Motion Rule 3:10-2, Section D and E. Now we go to trial. It's even going to be more the better because I'm pretty sure they don't want to take this to the trial, right? And I'm doing this all on behalf of the privacy rights of the Anglo-Saxon Berbers. The offenses and objection which may be raised before or at trial or after trial. The defense is that the indictment or accusations failed to charge an offense, and the defense that the charge is based on a statute or regulation promulgated pursuant to the statutes which is unconstitutional or invalid in whole or in part, may only be raised by a motion either before trial or within 10 days after a verdict or guilty or within such further time as the court may fix during such a 10-day period or on the appeal. So the only thing that can be raised before the trial or after trial is a motion for dismissal in regards to an unconstitutional statute and a pre-indictment arraignment, a pro-indictment arraignment. The other defenses are E. Such offenses should not be considered during trial, but after trial or before trial, they are permitted. Section E, lack of jurisdiction. The court should notice defense of lack of jurisdiction in the court at any time during the pendency of the proceedings except during trial. So we must understand how important it is to understand how the courts work in regards to get some type of remedy, okay, for the people. All right, we must understand how this works. And a lot of us don't even understand legalities, pardon, so. All right, especially when you're in a position as in the office here at the English Temple Church of England, you must understand civil legalities. All right, you must understand how the court works, criminal or civil. All right. So we see the motion for dismissal and the ground for a motion for dismissal based upon Section D and E, which are for lack of jurisdiction and an unconstitutional statute. Okay? You see it right there. Affirmative defense for me, i.e. your king. I was charged under 2C21:1-2.1A as well as 2C:21-3B. All right, these statutes in regards to the criminal complaint that was filed on behalf of the state, they're making or claiming that I, your king, has fraudulently charged and indicted the assumed defendant. Parts. Let me read that again. The plaintiff has fraudulently charged, because the state is the plaintiff in this matter, so therefore I'm calling them the plaintiff. I'm not going to read all this. I'm just going to read a little bit of it. The plaintiffs have fraudulently charged and indicted the assumed defendant with a criminal charge of violation of 2C:21-1-2.1A. A person who knowingly sells, offers, or exposes for sale, or otherwise transfers or possesses with the intent to sell, offered or exposed for sale, or otherwise transfer a document, printed form, or other writing which falsely purports, which falsely purports to be a driving license, a birth certificate, or other document issued by a governmental agency in which could be used as a means of verifying a person's identity or age or any other person identifying information is guilty of a crime of a second degree. So they're saying that the ID that we presented for just for me as well as for our members of the English Third Temple Church of England is a false document because it purports to be one, a driving license, a birth certificate, or any other document that issued by their government agencies and which could be used as a means of verifying a person's identity or age or any other personal identifying information is when they do that is guilty of a crime of second degree. That's the first crime they charged me with. 21 2C colon 21 colon 3-3B is the next one. Plaintiff has fraudulently charged and indicted the assumed defendant with a criminal charge of violation of 2C colon 21-3B, offering a false instrument for filing. A person is guilty of disorderly persons offense when knowingly that a written instrument contains a false statement or false information. He offers or presents it to a public office or a public servant with knowledge or belief that it will be filed with or registered or recorded it on the or otherwise become part of the record of such public office or public servant. So they're assuming that whatever I created and presented to the officer, i.e., public servant or public officers, that instrument might be put on the public record. Okay, this is what I'm being charged with. One, ID, false identification, which presumed to be a driver license, a birth certificate, or any other document created by their agencies, departments, etc. And two, creating an instrument and assuming that that instrument will be filed on the public record by a public officer who also is a public servant. Now, what we must understand that what might be offensive to them was justifiable as a result of my public office that I hold and the laws that allow me to do what it is based upon my public office that I hold as the King of England, which might be offensive to them based upon the laws in which they interpret or how they interpret it, but yet justifiable based upon how we interpret the law. So we must understand criminal and civil legality. All right? Very, very, very important. So in lieu of my affirmative defense to combat these two charges that they brought under 2C colon 21 colon 1-1.1A as well as 2C colon 21 colon 3-B, we must find a remedy, all right, under the criminal code that allows me to do what I do based upon who I say I am. Okay? Now, who I say I say I'm the King of England, and I speak on behalf of my people. And the laws that I make for my people is backed by the laws of my people. Okay? Very, very important. And the law justifies, even though it might be offensive to the practice that you do under the laws that you created to run your particular government, i.e., state. But the laws governing our society, i.e., our religious society, is governed by our laws. And under our laws, I have the right to, based upon the public capacity, the official capacity that I'm acting in as the King of England. We must comprehend that. So, what affirmative defense can I use in regards to the claim and the charges they're bringing forth in this assumed indictment and this pro-indictment arraignment? Let's see. Defendant affirmative defense to these charges is that he was acting in the capacity of a public office as established in New Jersey Revised Statute colon 2C3-C. This is the criminal statute, 2023. All right. Section 8 states, except as provided in subsection B of this section, conduct is justifiable when it's required or authorized by what? One, the law defines the duties or functions of a public officer or the assistance to be rendered to such officer in the performance of his duties. And two, the law governing the execution of the legal process. We must understand that. So based upon section 1 and section 2 of 2C colon 3-3, it says that I have the right to exercise the lawful authority that the law describes for me to exercise based upon my public office that I hold as the King of England. And we're going to see the statutes requiring that and allowing that based upon our certificate of incorporation, which the public record will show. The public record will show. All right. What's the next one? 2C colon 3-2 of the criminal statute. A. Necessity. Conduct which would otherwise be an offensive is justifiable by reason of necessity to the extent permitted by law, and as to which neither the code nor other statutory law defining the offense provides exceptions or defenses dealing with the specific situation involved in a legislative purpose to exclude the justification claim does not otherwise plainly appear. You see that? So there's some necessity in the laws that allow justifiability for you to exercise some type of authority that you have that otherwise would not be necessarily allowed. All right, because of the offensiveness of it. And section B, other justifications in general. Conduct which would otherwise be an offensive is justifiable by reason of any defense of justification provided by law, for which neither the code nor other statutory law defining the offense provides an exception or defenses dealing with the specific situation involved in a legislation purpose to exclude the justification claim and does not otherwise plainly appear. Okay, so we must understand that there are remedies when we are charged with criminal codes, when we are acting in the capacities based upon the allowed remedies in the criminal code. So we see in the criminal code, section 2C colon 3-3 and 3-2 allows for me to act in the capacity as a result of the laws that were put in place for me to act in my public capacity as a public office, which might be offensive to those who are now, this information is now coming to light to. Okay, so it might be offensive to them, but it's justifiable. Okay. The public record will prove that this was an invasion of privacy. Okay, invasion of privacy. Very important. Argument. The public records is governed under New Jersey Revised Statute colon 47 colon 1A-1, 2023 statute. The legislature finds and declares it to be the public policy of this state that the government records should be readily accessible for inspection, copying, or examination by the citizens of this state. Very important word, citizen of this state, with certain exceptions for the protection of the public interest and any limitations on the rights of access accorded by Public Law 1963, which is under clause 47 colon 1A-1 as sequence, as amended and supplemented, shall be construed in favor of the public right to access. So citizens of the state have the right to access to the public record for examination. That's in every state. In New Jersey, it's called OPRA, Open Public Record Act. Okay? All right. So it says all government records should be subject to public access unless exempt from such access as required by that clause 47 colon 1A colon 1, which deals with what? The public record. Why is this important? Because it states as amended and supplemented any other statute, resolution of either or both house of the legislature, regulation promulgated under the authority of any state statute, or any other regulation promulgated under the authority of any statute or the executive order of the governor or the executive order of the governor or rules of the courts, any federal law, any federal regulation or federal order, a public agency has the responsibility and the obligation to safeguard from the public access of citizens' personal information, with which has been entrusted with disclosures thereof, will violate the citizens' reasonable expectations of privacy. And nothing contained in clause 47 colon 1A-1 as sequence, which is the public record, as amended and supplemented, should be construed as affecting in any way the common law right of access to any record, including but not limited to criminal investigatory records of law enforcement agencies. We must understand what I'm doing on behalf of you all. Okay? New Jersey Revised Statute 47:1-5 also deals with the public record. This particular statute deals with those that were filed with the um, Secretary of State, the clerk, the Register of Deeds and Mortgages, and surrogates of any county of this state. And our records, based upon the public record, which is opening for examination, was filed with the county clerk and Register of Deeds. We must understand how important that is, because that's our proof that I, as your king, based upon the affirmative defense that I have raised under New Jersey Revised Statute 2C:3-3 and 3-2, that I have a right to act in the public capacity based upon the public office that I hold, which is justified by the law, which may be offensive to those who are now coming to light about this law that I'm raising in my defense. Okay? This will dissolve the criminal statutes that they have brought on behalf of presumed indictment based upon 2C:21-1-1.1A, as well as 2C:21 3-3B. Okay, those criminal statutes were brought forth on an indictment, which under the affirmative defense will be null and void based upon the justification of the laws that allow me to do what I am allowed to do based upon the office that I hold as a public officer, i.e., that will be your king. All right, let's move forward. Invasion of privacy is the Seventh Amendment constitutional violation and the Fourth Amendment violation on the state level, on the federal level. So this is a note to the judge. Invasion of privacy involves not one single tort, but in four distinct kinds of invasion of four different interests of the plaintiff or defendant, whichever you might be, which are tied together by the common name. Otherwise, they have almost nothing in common except that each represent a interference with the right of the plaintiff or defendant to be left alone. The four categories of invasion of privacy are A, unreasonable intrusions upon a seclusion of another, meaning they're coming into your space. Two, appropriation of name and likeness. A was unreasonable intrusions upon the seclusion of another. B was appropriation of another's name or likeness. So that means somebody else uses your name and your likeness. Okay. C, unreasonable publicity given to one's private life, and D, publicity that normally places another in a false light before the public. Okay. You can see Brisby versus John C. Conover Agency, which is a case dealing with public transfer, and I recommend that you go check that case out. Brisby versus John C. Conover Agency. So Brisby versus John C. Conover Agency. All right, this is 1982 case, and this is based upon the restatement torts. All right, and it's a property transfer case. Very important case. I read it myself. Let's move forward. All right, so we see the four examples of invasion of privacy: intrusion of seclusion, publicly being put in a false light, or bringing private matters to the public, which is your right to privacy, as well as appropriation of your name and likeness. How are they doing this? How are they committing these violations of privacy on the English subjects? Let's see. right here. Defects in the indictment process. Plaintiff has used a plaintiff I, that will be the state of New Jersey, has used a standard identification card issued under the Real Act ID of 2005, which is a clear violation of the assumed defendant's due process right as a citizen or a subject of this state. The charge is based on the statutes and regulations promulgated pursuant to statutes which are unconstitutional, invalid, and whole, as based upon 3:10 section D and E of the New Jersey Court Rules, as we read previously. Okay, very important. So they use an unconstitutional statute, and that statute governs what they call the standard identification card that one has in their possession if it's not a driver license or a birth certificate, which the charges they brought before on me was based upon your king trying to promulgate those three instruments: a driver license, a birth certificate, or the standard ID, which I was doing neither. Okay, we created our own national identity cards, which suffice for everything else. All right, very, very, very important. Why did we create our own nationality ID card? Right, to protect our privacy. All right. And we place it on the public record. And anytime that privacy right is violated, we have the right to examine the record, because that's why those who are in charge and entrusted were put there in the first place, to protect our identity as English, Anglo, Saxon, Berbers. But they have not done so. Why? Because the only ID that you have as a standard identification card for a citizen is what? A driver license, a birth certificate, a standard ID card, or a passport, or anything else they can create. All right? Very, very, very important for you to comprehend what's being said to you today. Section 1028 of Title 18 of the United States Code clearly tells you that the birth certificate, driver license, and a standard ID are not proper forms of identification. Okay, are not proper forms of identification. I ain't got time to read this. As a result of the time limit, this was actually spoken about in my previous lecture. So, for all those who didn't watch that, please go back and watch the previous lecture when I break that down. Okay, let's move forward. This is the focal point. This is the focal point. This is the focal point that I want everyone to focus on. In New Jersey Revised Statute 39:3-29 section B and 3B. Once again, New Jersey Revised Statute 39:3-29.3B. Okay. This is the statute governing the standard ID. All right. If you don't have this in your pocket, you got a driver license. Okay. If you don't have this in your pocket, you got a driver license, because these are the only instruments they give you in regards to how they identify you. Okay? This is how they identify you based upon the statute. Okay? We've seen what Title 18 of the United States Code 1038 says, that none of those instruments are proper forms of identification, but they are accepted as such. 1 second. Sorry about that. All right. This will make sense in a second. Our focal point is New Jersey. All right. No other state matters at this time. New Jersey, under 39:3-29.3b, states that as a condition for obtaining a real ID identification card, and everyone look on their ID card right now, it says not for real ID purposes. If you got an ID card or standard identification card for motor vehicles, it should say on it, not for real ID purposes or something to that effect. Okay? And if it don't say that, it should say that by 2025. 2025. All right. It says New Jersey Revised Statute 39:3-29 point 3b states that as a condition for obtaining a real ID identification card, two documents providing satisfactory proof that the applicant is a New Jersey resident, proof of the applicant's social security number or verification of ineligibility for social security numbers in accordance with the Real ID Act of 2005, Public Law 109-13. Any acts amendatory or supplementary thereof, and any federal regulations adopted thereunder, and proof that the applicant presence in the United States is authorized under federal law. Okay? Here's the kicker. Any document and personal information, including an applicant photograph obtained by the Commissioner of Motor Vehicles from an applicant for a standard identification card, shall be confidential. That means your driver license, your motor vehicle standard ID card, your passport, all these instruments are what we call confidential and should not be considered as government records pursuant to clause 47:1A-1 as sequence. We just read that, and it says citizens have the right to examine the public record, and they are obligated to the expectancies of the citizens to protect their privacy with those that are recorded on the public record. But if you have the standard identification card in your pocket as proof of identity, it's not going to be considered a part of the public record. It was never considered a part of it. It's not going to be considered a part of the record now. Or the common law concerning access to government records. All right. And should not be disclosed by the commissions for any purpose whatsoever related to Title 8 of the United States Code, which deals with nationality and aliens. Once again, Title 8 deals with nationality and aliens. Okay, so if it is not related to one's status as a citizen or an alien, then what does the standard identification card relate to? Okay, how are they identifying you if it's not based upon your citizenship, based upon your nationality, or your citizenship based upon that of a foreigner? Because the standard identification card or the motor vehicle card is a confidential instrument that's given between the applicant and the commissioner who works for motor vehicle. So according to that instrument, which you're producing for identification, has nothing to do with your identity or your status as a citizen or a subject based upon your nationality or based upon your status as a foreigner here in these states called the United States. And this particular point, we're talking about the state of New Jersey. If the two who are listening today, Countess Middleton and Countess Walker, if you understand that, please give me a thumbs up. If you understand that, please give me a thumbs up. If I don't have your full concentration in class, if you're doing something else that I can't have your total attention, you might as well log off and go and continue with your work. All right? Because if you're on class, I need you to respond. If you're here at class, I need you to respond. All right? Greetings, Brother Newly from the House of Newly. If you are a member and you're here watching these videos, when your king requests you to respond, you should do as told. Okay? Very important for you to follow instructions. If you're watching this lesson and I request that you give a thumbs up or make a comment, you should do so. If you don't, I'm assuming that you just here doing something else and just got the video playing. All right. So I'm only doing this for your own good. Why? Because if you're not doing what I say and you're not living according to the law that protects us, then that means that you're not getting no identification from us. All right. You chose your identity. All right. By the ID that you have in your possession, which usually results in a birth certificate, a standard ID card, or a driver license. Now, what's wrong with that? Don't worry about it, Countess Walker. Emoji, you don't need an emoji. Thumbs up is fine. Possession of a standard identification card issued pursuant to this section shall what? Shall not be considered as evidence of an individual's citizenship or immigration status and should not be used as a basis for an investigation, arrest, citation, prosecution, or detention. We must understand that if you are being arrested based upon that instrument called a standard ID, a driver license, a birth certificate, and any other thing that they create based upon their government, they are invading your privacy right. You're protected. Okay? They cannot give you a standard ID card. Okay? Parts of a nationality card. They cannot provide you with one. They have no authority to provide you with a nationality card. The card that they said that I was fraudulently creating was a nationality card. Now look what they say right here under Title 38 of United States Code, Section 1030, Title 18 of United States Code, Section 1038, before we move forward. United States Department of Justice. All right. Department of Justice specifically mentioned identification documents under Title 18, United States Code 1028. This is under the federal government. We're not talking about the states. Your citizenship is not part of the federal government because that only denotes the Naturalization Act of 1790 as well as the Immigration Act. The 14th Amendment, if you took that citizenship, that means that you really don't. If any type of remedy is going to come, it's going to come from your state citizenship, and that's yet to be determined. Why? Because it's not on a national level. It's on a corporate level based upon the intent why they created the instruments that identify you, such as the driver license, birth certificate, or a standard ID card under the Real ID Act of 2005. Okay? Section 1028 of Title 18 designates three special non-federal, you hear that? Non-federal identification documents and gives them preferred treatment. You hear that? So it's a non-federal identification card on the federal level, and on the state level, there are non-state ID. Why? Because it had nothing to do with your affiliation to the state as a citizen. Okay? We must understand how important this is right now before it's too late. Section 1028 of Title 28 designates three special non-federal identification cards or documents and gives them preferred treatment. These three documents in the absence of a national identity card. You hear that? In the absence of a national identity card are the prime means by which an individual establishes his identity in the United States. Did you hear what it just said? It had nothing to do with the federal government, but this is what they give you to identify yourself in the United States on the federal level: a birth certificate, driver license, and a personal identification card. It's right there. No one is excluded from this information. Now, the authority we have that most people don't realize is the power that the Roman Catholic Church have based upon their authority that's provided by the law for them to act in their official capacity, which might be offensive to some, but otherwise will be justified by the law. Okay, that's the same thing I showed you in the criminal statute 2C colon 3-B and 3-2 of the Georgia Revised Statute in lieu of the criminal statute that they charged me with under 2C 21 1-2 point 1A, as well as 21 colon 2C colon 21 colon 3B. Okay, those are criminal statutes that they charged me, and not realizing, based upon their stupidity, that law provides a remedy and is justified, and the law that provides a remedy is justifiable, even though it may be offensive. Why? Because I'm acting in my public capacity based upon the laws that allow me to act in my public capacity in my public office, which is verified on the public record, which we as citizens have the right to examine, i.e., subjects. Okay? If you're a citizen of the state, you got the right to examine the record. If you're a citizen of the King of England, you have the right to examine the record. But you must be affiliated with the church to be a subject of the Kingdom of England, because I am the King of England, based upon what the record will show you. All right? Let's move forward. Title 8. Title 8 of the United States Code. Title 8 of the United States Code codifies statutes relating to aliens and nationalities in the United States Code. So if the ID that you're given by a motor vehicle to any state of the United States has nothing to do with Title 8 of the United States Code for no purpose or intent, is that ID in your pocket to be affiliated with anything that's associated with the government on the public record level, as well as anything to do with Title 8 that has to deal with either a nationality, which is your subjectivity or citizenship to your nation, or your alien status from you actually leaving your mother nation or your nation in which you originated from. So we must understand the situation that a majority of you are in right now. You're in this situation. So the power we have is to redeem you from that troublesome world that you're in based upon our power that we have. That might be offensive to some, but it's justified by law, based upon the law that allow us to act in our official capacity. Okay? We must comprehend. Now look what the Roman Catholics are doing. This is Archbishop work. To help immigrants feel safer around police, some churches started issuing out what? IDs. You hear that? Some churches start issuing out their own IDs. Ain't there a separation of church and state? All right? If there's a separation of church and state, the separation of the state is the separation of the body of politics, not just the church and the belief that the church believes in. Because and when they separate the church from state, they allow you to believe whatever you want to, but it's not attached to a government that will protect that belief that you're allowed to believe in, and that's whatever you want to. Okay, so you must have some belief that is attached to a body of politics that can protect that belief, and instead of some belief that you can believe in whatever you want to, but ain't gonna be protected. Okay, which 9.9% of you are in that position. Okay, you're in that position. You believe in something that has nothing to do with your present status as a citizen, okay, or as a subject, because we as subject of the Kingdom of England had a religious belief. Okay, we had laws we had to follow. We had customs and traditions that we must honor. Okay, everybody who actually joined in the Roman Catholic Church who getting ID cards are immigrants. They're foreigners. They gave up their national ID to become a foreigner, a naturalized citizen. This is what the Roman Catholic Church is doing all around the world, including here. Okay, and they're doing it right under your eyes. Why? Because you don't want to be national. All right? You don't want to be standing on your national standards. All right? You want to be a naturalized citizen, a foreigner, and you become a foreigner when you create some identity and then try to get yourself protected under some foreign law. Okay? A foreigner is not going to protect some foreign law that they don't recognize in law. Okay? That's called uniformity in law. So let's read a little bit more before I move forward. For immigrants living in the United States illegally, it can be difficult to get a valid identification card. Now there's one very old organization trying to make it easier. What? The Catholic Church. The Archdiocese of Baltimore announced Wednesday that its parishioners will now be able to get an ID for itself. Will now be able to get an ID card that shows the name, address, and data of birth accompanied by the parish logo. While the cards clearly states they are in government issued IDs, the city of Baltimore and its police departments say they will recognize the card as an official form of identification. Okay, so you see, the Roman Catholic Church are allowing immigrants to receive identification cards that has nothing to do with the government. Okay? Nothing to do with the government. So this is a ring, this is a circus. All right? What the Roman Catholic Church is doing, all states are now doing, based upon the standard identification card that you hold in your pocket that has nothing to do with your status as a subject, as a citizen, or as a foreigner. Everyone who understands that are here tonight, please give me a thumbs up if you understand that. Okay? If you understand that. Let's go, let's go, let's go. I'm waiting for my thumbs up. I'm waiting for my thumbs up. If you was in class, you wouldn't be able to be moving around like that. You stuck in class till that bell ring. So them thumbs up should be coming up right after the statement is made. Let's go, let's go, let's go. Let's get it, y'all. We ain't playing around here. Expectancy of privacy in the United States. In the United States constitutional law, expectation of privacy is a legal test which is a crucial in defining the scope of applicability of the privacy protection of the Fourth Amendment to the United States Constitution. In New Jersey, it's called the Seventh Amendment. All right, it is related to, but not the same as, a right to privacy. A much broader concept, which is found in many legal systems, see privacy law. Overall, expectation of privacy can be subjective or objective. Okay? We must understand expectation of privacy. Okay? Expectation of privacy falls under what they said, privacy laws. So let's look at privacy laws in the United States. Just look at it. Privacy laws. Privacy laws of the United States deal with several different legal concepts. One is the invasion of privacy. You hear that? A tort based in common law allowing a aggrieved party to bring a lawsuit against the individual who unlawfully intrudes into their private affairs, discloses their private information, publicize them in a false light, and appropriate their name for personal gain. This is what's being done by the standard identification card, by the driver license, by the birth certificate, by any other instrument that's created by the government. Why? Because it has nothing to do with your nationality as a national, as a naturalized citizen, as well as a foreigner. It all has to do with commerce. Okay? Whether you do something about it or not, you are a product of commerce. This is why your king had to file a lawsuit on behalf of all his people whose privacy had been invaded as English, Anglo, Saxon, Berber. This is the reason why they filed a lawsuit against me in the first place, because I was going back to restore the estate that was taken in the first place by me acting in the capacity based upon the law that requires me to act in that capacity in my public office as the King of England, and based upon the statute required in the criminal statute under 2C colon 3-2 and 3 colon 3-3, it might be offensive to them, but it is justifiable. Okay? It is justifiable. Why? Because our privacy rights as Anglo-Saxon Berbers have been invaded based upon the IDs that they give you to identify us has nothing to do with proper identification. Because in order for the court to have jurisdiction, they must have over the subject matter, they must have jurisdiction over persona, i.e. the person. And based upon the Fourth Amendment of the Constitution and the Seventh Amendment of New Jersey Constitution, we have the right to be protected, and persons, 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 in effects, houses, etc. Okay, we understand what that Fourth Amendment and Seventh Amendment right is. Okay, to be protected in persons, houses, effects, papers, documents, etc. All right, we must understand that. Let's move on from here. All right. Let's go to the actual statute to prove my point. This is the New Jersey Revised Statute 47 colon, what is it? 47 colon 1A-1, the public record. Okay? The public record. All right? Very important. Every citizen of the state, with certain exceptions, has the right to examine the public record. You hear that? Examination by the citizens of the state, with certain exceptions, for the protection of the public interest, and any limitation of the right of access is accorded as amended and should be construed in favor of the public right to access. Okay? To access the public record. And it says that, where's it at? All governments records should be subject to public access unless exempt from such access as under 47 colon 1A-1 in sequence, as amended and supplemented any other statute, resolution of either both House of the Legislature, regulation promulgated under the authority of any statute or executive order of the governor, executive order of the governor concerning the rules of the courts, any federal law, federal regulation, or federal order. Okay? We must understand that they have the highest obligation as part of a public agency, and they have a responsibility and obligation to safeguard from public access a citizen's personal information with which it has been entrusted when disclosed thereof would violate the citizen's reasonable expectation of privacy. So what is your expectation of your privacy right as citizens, okay, under the law? Because our expectations of privacy as subjects under the law, which we interchange with citizens, is based upon the common law. And it says, as amended and supplemented, should be construed as affected in any way to common law right. So our subjectivity as citizens are protected by the common law, which is the law of every municipality. Okay? Very, very, very important for you to understand that. And based upon our certificate of incorporation, we are obligated, not just as members, not just as officers, but as your king, because my people don't have a king. They haven't had a king for so long, so therefore I must become that person, i.e. king, to represent the people. Okay, and as a result of that, it caused me to act in a public capacity under the authority that the law requires me to act in my public capacity as a public officer on behalf of a public trust. And the law provides exceptions, which might be offensive to some, but it's also justifiable in the eyes of the law. So says the law. Okay, we must comprehend. All right, so we declare who we are as citizens. Why? Because based upon that standard identification card that 99% of the citizens have here in the United States and in all states is that standard ID card, right? It is that standard ID card. You have this in your pocket. And it clearly says in the statute relative to that ID card that that document right here in the statute states, okay, it says it in the statute. This is my defense, my affirmative defense, that any document and personal information, including any applicant's photograph obtained by the commission from an applicant for a standard identification card, should be confidential. So that means that the police officer, the sheriff's department, the courts, or anybody for that matter should not have the information that the commissioners of motor vehicles now have in their possession, because that's a private contract. It was not supposed to be used for public agendas. Okay, it was not supposed to be used in the public. When they used it in the public, that violated your invasion of privacy, especially when it comes to that identification card, because it has nothing to do with your citizenship or your status as an immigrant. Okay, that's why it cannot be used in any investigation, arrest, citation, prosecution, or detention. Let's read it for ourselves. Any document and personal information, including the applicant's photograph obtained by the commission from the applicant for standard identification card, should be confidential. It should not be considered as a government record pursuant to the statute been going on all night, 47:1A-1, or the common law concerning access to government records. So under the common law, you have the right to access of the government records. But if you're not under the common law, you have no right to the access of government records. Why? Because you are not a citizen. I don't know what you are based upon, because they have not defined what you are. Okay? So it says that or under the common law concerning access to government records, it should not be disclosed by the commissioners for any purpose related to Title 8 of the United States Code. And we know that has to do with what? Nationality and aliens. We know if you're a citizenship, you not necessarily have to have a nationality, especially if you're a foreigner. All right? I hope that makes sense to everyone. Title 8 United States Code without informed consent of the applicant, i.e. you, or a warrant signed by the state. So if they're arresting you and doing all these things that this statute says not to do, that means they must have got that okay from who? That federal judge or lawful court order or subpoena. All right, so they must have the authority somehow. If they didn't get it from you, they got it from the state, federal judge, lawful court order, or subpoena. Why you think they subpoenaed to come to the courtroom anytime they feel like it? Why? Because you gave way. You were the applicant that allowed them to do so without reading the fine print, the fine line, the disclosure statement. It's very, very, very important for you to comprehend that. When responding to a warrant court order subpoena, the commission may disclose only those records or information specifically requested in the warrant court order and subpoena. So meaning that when they arrest you for driving on the wrong side of the road or a traffic ticket or a violation, the only information they can get in the court of law is based upon the violation. They shouldn't use that information to identify you, but yet they do, because there's no other instrument out there to identify you based upon the definition of what the standard ID or the motor vehicle or even the birth certificate fit in absence of what we call a nationality ID card. If everyone understands that here tonight, please give me a thumbs up in the chat. While you're doing that, it goes on to say, possession of the standard identification card issued pursuant to this section should not be construed. Should not be considered evidence. You hear that, y'all? It's not going to be considered evidence of your citizenship or immigration status. It should not be used as the basis for investigation, arrest, citation, prosecution, or detention. But isn't that how they lock you up? Isn't that how they do investigations? Arresting you, giving you citation, prosecuting you, detaining you. They do it based upon that instrument called a standard identification card or a driver license, but it's not a proof of identification card of your true status as a subject or a citizen. It does prove you're a citizen of the state because the state don't give a damn if you're a citizen. The only thing they're using it for is what? Their private or public commercial agenda. We must comprehend what's going on. This is the reason why I stress to you to understand who you are as Anglo Saxon Berbers, because you're going to have to remember this to be able to stay here, okay? Here in these lands. You must comprehend that. Why is this important? Let's see. I'm going to get off that topic because I've been on it in my last lesson. So all those who want to get a little more insight of what we discussed in the past half hour or so, please watch my last lesson. But now I'm going to get into why it's important to understand your status as a subject of the King of England. All right? It's very important to understand your status as a subject of the Kingdom of England. Let's see why. Brown versus United States. Everyone needs to get this case. 756 years understood in a couple of minutes. All right? 756 years understood in a couple of minutes just here with your king. All right? Brown versus United States, 12 U.S. 110 1814 case. All right? We know who we are. We are the English Anglo Saxon Berbers. We know who stole our state. United States, i.e., the colonies, as well as the Scottish monarchs, who were the British monarch. Okay, we know they stole this land here called now North America. All right, they stole this land and act like we came over from cross seas, which are called overseas territories or overseas possessions or overseas dependencies. Okay, that's not the case. We were always here on this land. All the property, i.e., all the land, all everything that is attached to the land, even the people, were us. How do I know this? Let's see what Brown versus United States has to say. All right. British property found in the United States on land at the commencement of hostilities with Great Britain cannot be condemned as enemy's property without legislative act authorizing its confiscation. I repeat, British property found in the United States on land at the commencement of the hostilities with Great Britain cannot be condemned as enemy's property without a legislative act or authorization of its confiscation. Okay? The act of the legislator declaring war is not such an act to declare property to be taken by another party who's at war, because this will be subject to what we call prescription of sovereignty. Okay, through what we call eminent domain or compulsory purchase. All right, this is how land is required. All right, through conflict. All right, so it clearly says that British property found here in the United States on land at the commencement of a hostility between Great Britain. And we know Great Britain originated what year? 1707, between the Union of Crowns. Prior to that, England was separate from Great Britain. We must comprehend that. And we're talking about property of the United States that Great Britain had in their possession that actually belonged to the English crown, okay? That was over here in the United States being confiscated at the time of what we call the Revolutionary War, all right? The act of the legislature declaring war is not such an act. Timber floated into saltwater creeks where the tide ebbs and flows, leaving the ends of the timber resting on the mud at low waters and prevented from floating away at high waters by booms is to be considered as landed, okay? In this country, from the structure of our government, proceedings to condemn the property of an enemy found within our territories as a declaration of war can be sustained only upon the principles that they are commenced in execution of some existing law. Okay? They can only be commenced in the form of some existing law. Okay? So property can only be confiscated by way of some existing law. And the existing law based upon the confiscation of land, if it's from an enemy, can only be what they call bona vacantinia, abandoned property. Okay? Abandoned property. It says in England, though, all property captured belongs originally to the crown, and individuals can acquire a title thereto in no other manner than by a grant from the crown. I repeat, in England, all property captured belong originally to the crown, and individuals can acquire a title thereto in no other manner than by grant from the crown. It didn't say Great Britain, it said the crown, because Great Britain was sitting on the crown, and the crown prior to Great Britain being occupied by them was the crown of England, because it said in England. So we're talking about the English crown. All right, very, very important. Wars give to the sovereign full right to take the persons and confiscate the property of the enemy wherever found. The mitigation of the rigid rule which the policies of modern times has introduced into practice, although it may affect its exercise, cannot impair the right itself. And when the sovereign authorities should choose to bring it into operation, the judicial department must give effect to its will. Until, however, that will is expressed by some legislative act, no power of condemnation can exist in the court. So until that will of the sovereign brings the confiscation of property into effect, it still remains abandoned property by way of whoever discovered it. But when that operation comes into effect by way of the concept of the crown, which is based upon what? The right of escheatment, okay? To take which nobody knows who owns it, okay? A right of escheatment. We must understand. So once again, war gives to the sovereign full right to take the persons and confiscate the property of the enemy wherever found. The mitigation of the rigid rule which the policy of modern time had introduced into practice, although it may affect its exercise, cannot impair the right itself. And when the sovereign authority shall choose to bring it into operation, the judicial department must give effect to its will. Until, however, that will is expressed by some legislative act, no power of condemnation can exist in this court. All right. Why is they saying this? Let's see why. All right. Let's see why. New Jersey revised statute. You see it for yourself. New Jersey revised statute Title 46, 30B1. This statute is called the Abandoned Property or the Uniform Unclaimed Property Act. Once again, this chapter should be known and may be cited as the Uniform Unclaimed Property Act, or what we call bona vacantinia. This was an act incorporated in the state of New Jersey, 1989. Okay? You see it right there. All right. So we can all agree there's a statute in New Jersey that allows the state of New Jersey to take abandoned property known as unclaimed property. Okay. We know the unclaimed property cannot remain in the state of New Jersey because we just read a court case says that the abandoned property has a right to be reclaimed by the sovereign once the sovereign put that act in motion. Why? By way of authorization. The authorization is based upon a law that allows the authorization to take place because land transfer by what we call operation of law. Land conveyance, if there's no will, transfer by way of what we call operation of law. Okay? Why is this important? Because if we see Title 46 under colon 30B1, it's called the Uniform Unclaimed Property Act, and Unclaimed Property Act is abandoned property as a result of interstate, then automatically it reverts back to the crown, just like they said in Brown versus United States. It automatically reverts back to the crown. Let's see it. Let's go to the actual case. State versus Elevator Company. (1953) case. Can't make this up. In modern usage, a street signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owners' whereabouts is unknown. Under the common law of England, a street came to be classified as another branch of the king's what? Ordinary revenue. Blackstone Commentary 302 states what was originally an incident of tenure is now an incident of sovereignty. The doctrine was treated at the early common law operative only upon that which was the subject of tenure, since it related to the reversionary right of the lord to take for what? One of a tenant, was eventually extended to include what? Personal property, tangible and intangible. The principle was the right to take that which belonged to no one appertaining to what? The crown as part of the crowns of the kings or the monarchs' jural regalia. You hear that? The crown steps in to take that property because it is vacant. Property described as bona vacatina is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right and the exercise of its sovereign power. In personal estates which are allodial by law, the king is last heir where there is no kin. You hear that? The king is last heir where there is no kin. So if private property or abandoned property called bona vacatina is taken by the state, who has the right to take it based upon what the statute said? The crown. And who represents the crown? The king, by who it's called what? And the corporation sold. The public record will show that the public record, when we verify the public record based upon 47 colon 1A, what was that statute? What is the statute for the public record? Let me get it. 40. Look at that. New Jersey Revised Statute 471A-1, which governs the public record. If you go to the public record, you will see that our certificate of incorporation, i.e., our charters, and the laws that are in our charter allow me as your king to operate under the laws, i.e., the law of the common law, to operate in my public capacity, right? And based upon, and that's governed under the criminal statute 22C colon 3-3. And as a result of that public office that I hold and the laws that allowed me to act in that public office based upon the law, allows me to do what I do, which might be offensive to those of the state, but it is justifiable pursuant to criminal statute 2C colon 3-2. Okay? So I have an excuse to do what it is that I'm doing because not only does the statutory law provide so, but the case law provides so as well. Greeting, Brother McGarrell from House McGarrell. Glad you could join me as well as everyone who are here tonight are able to join me. Okay? So we understand that the bond of vacating of property that the state of New Jersey has took it upon themselves to take rightfully belongs to I, your king. Okay? Rightfully belongs to I, your king. Now, why is this important? Let's see. All right, let's close this timeline of 756 years. New Jersey Revised Statute 46:3-5. Same statute, governing property. We just read the statute 46:30B, which deals with abandoned property. Okay, unclaimed property under the statute. We just read the statute. Let me go there again. Show you again. Right here. Title 46. This is all statutory proof that everyone can see without a shadow of a doubt. Unclaimed property, or the uniform code for unclaimed property. And we know what elevator, state versus oldest elevator says, that belongs to the crown. Okay, let's see. Let's go to the revised statute. Still under Title 46. Alienation of freehold. Statute Queen and Pretoris. Terum. Talking about abandoned property now, right? All of us, or all of you, are considered abandoned property. Okay? So it says here, alienation of freehold, statute Queen and Pretoris. From after March 18th, 1795, any freeholder, we already know who the freeholders, those who watch this lesson, those are the ones who turned our intel estate into what we call fee simple, all right, through a process called common recovery, which was unlawfully done, all right. That was a violation of Queen of Pretoria. That was passed by Edward I on Plantagenet King from the Kingdom of England in the 12th, 13th century. He passed this law that has now somehow made its way into a New Jersey statute in 2023 called the Statute of Queen and Pretoria. This statute of Queen of Pretoria was the statute passed by Edward I that allowed land to be substituted but not sold through what we call civil feudation. Why? Because the land was entailed and it only belongs to you as heirs of the estate. All right, but the landlord who was overseeing the estate and the heirs put the heirs in slavery, i.e., those freeholders put you in slavery and sold you along with the land, i.e., fee simple season. Okay, so it says any freeholder may give, sell, or alien the real estate whereof he is, or at any time should be seized in fee simple or any part thereof at his pleasure, and such donee, purchaser, or alienee shall hold the same free of anything or service to the donor, seller, or aliener. All right, so this is as we can see, a legal trail of the conveyance or the transfer of the land conveyance that was unlawfully done by the freeholders through a process called fee simple. And it goes all the way back to Queen Imperatrix, which is a statute passed by who? Edward I of the Plantagenet crown. Okay? He also passed a statute that made its way into New Jersey by a statute called the Statutes of Entail. The Statutes of Entail. What is that statute? Under Title 46 as well. All this was the unclaimed property that now sits in the hand of the state of New Jersey, as well as the United States. All right? Not just New Jersey, but the whole United States belongs to the Plantagenet crown. I'm going to prove it to you tonight. Estates entails abolished. Whenever any conveyance, i.e., transfer, will or instrument in writing shall hereafter be made, whereby Any grantee, devisee, or other person should become seized in law or in equity of such estate and real estate as under the statutes of 13th of Edward the First, called the statutes of entail, would have been held as an estate in fetail of a type or character. Now such conveyance will or intimate shall vest an estate in fee simple and such grantee, devisee, or other person. So all those who descended down from Edward the First of the Plantagenet crown who were to receive an estate entail based upon their birthright, now that estate has been stolen by freeholders through common recovery by conveying the land from fee entail to fee simple, which we see right here in the statute. If everyone understands that, please say yes in the comments. Everyone, please say yes in the comments if you understand that the land that was under the authority of the monarch Edward I was changed from entail to fee simple by way of what we call common recovery practice, and through Quint and Pretorius, they had subdivided the land by way of selling it other than what it was required through what they call substitution. If everyone understands that, please chat yes in the chat line, please. Come on, y'all. Let's go. Let's go. Let's go. Okay. Let's rock. No one is excused. Let's go. Let's go. Estates entail are abolished. That means that all you, all of you who are watching tonight, your estate has been abolished by your modern day commissioners, which were previously called freeholders. Okay, they were called freeholders. They took your estate, going all the way back to Edward the First. Okay, so as you can see, you see a timeline from the 2023 going all the way back to Edward the First. Okay, from Edward the First all the way back up to now. Because why is his name in this statute? So that meant that he must have had something to do with the territory here in what you call now the state of New Jersey. He must have something to do with that. But how do we know that? All right, we see him in the statute. We see that the estate, i.e., the land that he preserved for the heirs who are now coming to the understanding of who they are able to understand that. If they're able to understand it, then they're able to receive it because it was conveyed not by deed but by library of law. It was a promise. All right, they didn't write nothing down. They told him, when you remember this, you can go get it. All right, because it was a promise through a ceremony called the Twig and Turf ceremony, going all the way back to Asterton, the son of who? Edward the Elder, the son of who? Alfred the Great. Okay, so we see our estate entail were abolished, and as a result of that, it became a part of crown land, and crown land is entail, which personified by the crown who makes it up. Okay, and me being the crown, the only way I can retrieve the land is by bringing a claim to the land, which is my lawful duty to do based upon the law that allows me to do it as a result of who I am and the office that I hold based upon the public office, which might be what, according to affirmative defense, might be offensive to some, but it's justifiable by the law. Okay? It's justifiable by the law. Now, why is this important? Why is Edward the First, the son of Henry the Third, all right? The son Edward the First, the son of Henry the Third, and Henry the Third was the son of John, the son of Henry the Second, the son of Godfrey, the fifth Caliban Jew, the son of Folk, the ruler of Jerusalem, which I am a descendant of. Okay, why is all these descendants of ours have a some type of history pertaining to that of New Jersey? Because let's go back to invasion of privacy. Very important. Invasion of privacy. What does it mean to invade someone's privacy? One of the examples of invading privacy is going to be put into a false light. Okay, this is what they're doing by that standard ID or that driver license or that birth certificate. They're putting all the English Anglo-Saxon people into a false light. Okay, into a false light. So a false light is light that's not light from the sun. It's a light that is artificial light. Okay, this is your hell. This is your prison. Where is that at? All right, right here. This is false light invasion of privacy. Tell me if everyone feels this way. Because when I filed this lawsuit, y'all filed this lawsuit along with me. So whether we're plaintiff or defendants, we still feel the same, or we should feel the same. So once I read this little edit right here, everyone give me a thumbs up if you feel the same way I feel based upon how the state has put us into a false light. Okay? It says the plaintiff alleges that the defendants, i.e., the state, has invaded our privacy by placing us in a false light before the public. By this, we mean that the defendants, i.e., the state, publicized material about us that is false and is so much a misrepresentation of our character, our history, activities, or beliefs that a reasonable person in the plain position will either be expected to take serious offense or be justified in feeling defendant or agree. I repeat, we as plaintiff, or in this case, we're defendants, allege that the plaintiff, i.e. the state, has invaded our privacy by placing us in a false light before the public. By this, we mean that the uh, plaintiff, i.e., the state of New Jersey, publicized material about us, i.e., based upon that birth certificate, that standard ID, or that job license, that is a false and in such a manner misrepresentation of us based upon our character, our history, our activities, as well as our belief that a reasonable person in our position would either be expected to take serious offense or be justified in feeling offended or aggrieved. Do everyone feel like they are offended by way of how the plaintiffs, either the state of New Jersey or any state that you're in, as a result of what you know now, have put you into a false light? How many of you are upset about that? Based upon what you know about yourself now, based upon you having a history, a character, and belief, based upon you having a culture, i.e., a citizenship based upon your nationality, contrast to what that standard ID, birth certificate, or driver license gives you, which has nothing to do with your nationality, ID, etc. Okay, that's what I want to hear. All right. Everyone respond. Everyone needs to respond. So they have erased the character, the histories, as well as the activities that our beliefs depend upon. All right. And if you understand what we're saying here, then you read to believe that we are actually offended and aggrieved by what they're saying or what they're proclaiming or declaring based upon those records that they keep on us that are not even on the public record. They're not even on the public record. So everything that they're doing based upon those IDs are private, confidential. All right. And all this is coming to light now. All right. I'm proving that all the Anglo-Saxon English people were put in a false light as a result of how they characterize us as citizens. They didn't even call us citizens. We don't know what the hell we are. We must comprehend what's going on. All right. So now let's get into the good part. All right. We see Edward the First, our long, long, long past ancestors from the 12th century had reserved our estate in the 24th century. Okay, in 2024, they have put in statutes that they have stolen our estate. They have stolen our estate. Character assassination. You're absolutely right. Character assassination. All right. Now, how we know this, that they have done this, all right? How can we prove that we are these people that they assassinated and who have the character based upon the characteristics that were quoted in the statute at Edward the First? All right? Because we saying we're kindred or descended down from Edward the First, we got to be able to prove what we're saying based upon how they took our land, took our history, took our culture, took our laws, etc., and used it for their own, and gave us something that had nothing to do with who we really are. All right, we must be able to prove that. No one else has proven that based upon the identity of a people that have or declare a nationality on the public record. You hear me? Declared it on the public record. We declare our nationality on the public record. Let's go back here. Pre-indictment. Let's look at it. Menticide. I ain't heard that word before, but yeah, I guess that could be. I guess that could be true as well. All right. Menticide. Let's see. Now this is my motion for dismissal. All right. This is my motion for dismissal. And we can prove everything we're saying based upon the public record that we have the right to examine. And in my testimony attestation, I attest to the fact that we are who we say we are. And the constitutional officer has verified who we are. Why? She called me king in the prosecutor probable cause affidavit. She actually called me king. So I know based upon the record is that not only is this charge is going to be dismissed, they're going to be charged with impersonating uh, uh, the identity of people who don't even exist. They're misappropriating the name and likeness of people who don't even exist when actually these people do exist as English, Anglo-Saxon, Berber. And as a result of that, they have violated their own statutes. What is the statute they have violated? Let's see before I move forward. Look at it. They have violated their own statutes. Right here. Now, I told you on the criminal statute 2C colon 3-2 and 3-2 that based upon the public trust that I hold in my public office, based upon the law that allows me to act in my public capacity in my public office, that what they seem offensive to them is justifiable under the criminal code 2C colon 3-3 and 3-2. All right. And as a result of me doing what I have to do based upon what I'm allowed to do based upon the law, as a result of them not properly classify us as English, Anglo-Saxon, Berber. Someone had to do it because we said those 4 instruments that they give you do not satisfy the requirements of a national ID. Hell, they don't even satisfy an instrument that denotes to citizenship. All right, so I had the obligation to do that on behalf of the people. Why? Because what they were doing, based upon how they brought the claim against us, was impersonating the identity of Anglo-Saxon English people into identity of something that don't even exist, especially if it don't have a citizenship status. Who the hell are you if you don't have a citizenship? What are you if you don't have a citizenship? Okay, so based upon the criminal statute that they say I violated, based upon 2C colon 21 1 what is it 2C colon 21 dash 1 dash 2.1a, as well as New Jersey Revised Statute 2C colon 21 dash 3b. They're saying that I created a false instrument as well as a false ID. All right. And they said that the ID I created was impersonating a driver license, purported to be a driver license, a birth certificate, or a standard ID. Okay, which I was doing neither. I was creating a national ID for our people. All right. Why? Because the IDs you created were impersonating our people. Okay, and to something as product and other than something as a natural person. Okay. Yes, sir. They judge the dark-skinned Anglo-Saxon Berbers. So in this clause, they have impersonating the theft of identity of an English Anglo-Saxon people. All right. This is a violation of law. Impersonating theft of identity. A person is guilty of a crime if the person engages in one or more of the following actions by means of including but not limited to the use of electronic communication or internet website. How did he get the information? From the internet, the website, right? What is it? Uh, one, impersonates another or assumes a false identity and does an act in such assumed character or false identity for the purpose of obtaining a benefit for himself or another or to injure or defraud another. You hear that? Two, pretend to be a representative of some person or organization and does an act in such pretended capacity for the purpose of obtaining a benefit for himself or another or to injure or defraud another. This is what your states are doing. They're defrauding you. They're invading your privacy by saying you are somebody other than who you say you are. Okay? So they're impersonating you. Three, impersonating another assumes a false identity or make false or misleading statements regarding the identity of any person in an oral or written application for services for the purpose of obtaining services. That's what the motor vehicle instrument does. All right? It's a contract. It's an agreement between the applicant and the service provider. Okay? It has nothing to do with proper identification. All right? Four, obtain any personal identifying information pertaining to another person and use that information or assist another person in using the information in order to assume the identity of a or represent himself as another person without that person's authorization and with the purpose to fraudulently obtain or attempt to obtain a benefit or services or avoid the payment of debt or other legal obligation or avoid prosecution for a crime by using the name or a person. Or five, impersonate another or assume false identity or make false or misleading statements in the course of making an oral or written application for services with the purpose of avoiding payment for prior services. Purpose to avoid payment for prior services may be presumed upon proof that the person has not made full payment for prior services. Isn't this the situation we're in? They owe us and don't want to pay us. Right? They owe us and do not want to pay us. But the law says you have to. Why? Let's see what the law says. Where is it at? It's right here. Let's see. All right, yeah. 2C 20:21-17. So impersonating the death of identity is a violation of law. Let's look at the next one. Restitution to victims of unlawful use of personal identification information. So we can get restitution based upon the criminal statute. Everyone see that? Restitution to a victim of a offense under 2C New Jersey statute 2C:21-1. When the offense concerns personal identifying information may include costs incurred by the victim in clearing the credit history or credit rating of the victim or in connection with a civil administrative proceeding to satisfy any debt, lien, or other obligation of the victim arising as a result of the actions of the defendant. Everyone see what can happen when we bring this to light about them improperly using our information for commercial gain? Because this is what they're doing. They're using our identity for commercial gain. And as a result of that, that's a violation of our privacy by bringing our public information into a false light, bringing our private affairs into the public, as well as an appropriation of name and likeness, as well as an intrusion upon our personal space. Everyone must understand that. Understand that. As a result of that, we have the right to restitution. What else do we have a right to? Use of personal identifying information of another is in certain degrees of crime. Let's see. All right, so you can go to jail for this. I'm not going to get into read all of that as a result of the information I still got to talk about. Let's see what else. Part 3. Trafficking in personal identifying information pertaining to another person, certain crimes, degrees, and terms defined. Okay? In terms defined. What else? Section 4. Action by a person defrauded by unauthorized use of personal identifying information. So they're defrauding us as well. Let's read it. Any person who suffers any ascertainable loss of money or property, real or personal, as a result of the use of that person's personal identifying information is a violation of New Jersey Statute 2C:21-1. All right? May bring an action in any court of competent jurisdiction in any action under this section. The court shall, in addition to any other appropriate legal and equitable relief, award damages in an amount of 3 times the value of all costs incurred by the victim as a result of the person's criminal activity. These costs may include, but are not limited to, those incurred by the victim in clearing his credit history or credit rating, or those occurring in connection with any civil administrative proceeding to satisfy any debt, lien, or other obligation of the victim arising as a result of actions of the defendant. The victim may also recover those costs incurred by attorney fees, courts costs, and any out-of-pocket losses. A financial institution, insurance company, bond association, or business that suffers direct financial loss as a result of the offense shall also be entitled to damages, but damages to natural persons should be fully satisfied prior to any payment to a financial institution, insurance company, bond association, or business. Do everyone understand what's going on? Did anyone or everyone comprehend what was just stated by the statute? Everyone say yes or no of the rights that you have that are right now at your disposal. Okay, at your disposal and are being exercised right now by your king. Do everyone understand that? Come on now. Yes or no? Let's go. All right, let's really bring it home. I'm still waiting on my yeses. Everyone, everyone. Be honest. If you don't understand, go back and read it after this lesson. If you do, don't say you do and you don't. All right. So they are impersonating the English, Anglo, Saxon, Berbers, and since you or the heirs don't exist, the only one can bring a claim on your behalf is I, your king. Okay, and all the remedies, all the damages that you are owed, I am going to get it for you. All right, I am going to get it for you, but you must be yourselves. Who are we? We are descendants of the Plantagenet dynasty. English, Anglo, Saxon, Berbers. Why? Because according to Edward I, he left our estate intact, intel. But they gave up uh, the protection by not maintaining the obligation of the overseer, which was rightfully reserved for a king. That's our problem. The people have no king. therefore they have no rights. The people have no king, therefore they have no rights, because the people don't know the history about their king pertaining to here. Because Edward the First is in the statute, and he's telling you in the statute that if you understand your history, then a land can be returned to you if you are an heir. Because it was taken from the heirs of the Plantagenet dynasty and then given to everybody else who are not heirs of the Plantagenet dynasty. How do I know this? Well, let's take a view back through history, okay? Let's take a walk back through history. Because we just read in this case law, Brown versus United States, that the property, you're right, no king means total anarchy. I like that. And you are living in an anarchy right now. Once again, in this country, from the structure of our government, proceedings to condemn the property of an enemy found within our territories as a declaration of war can be sustained only upon the principle that they are commenced in execution of some existing law. In England, all property captured belonged originally to the crown. An individual can acquire a title thereto. An individual can acquire a title thereto in no other manner than by a grant from the crown. So if you got a grant from the crown, that means you got a charter from the crown. War gives to the sovereign full right to take the persons and confiscate the property of the enemy wherever found. The mitigation of the rigid rule which the policy of modern times had introduced into practice, although it may affect its exercise, cannot impair the right itself. And when the sovereign, you hear that? When the sovereign authority shall choose to bring it into operation, the judicial department must give effect to its will. Until however that will is expressed by some legislative act, no power of condemnation can exist in the court. Guess what? That power has now been called upon by I, your king, in the courts of the king. How we know that? Let's view it. Let's go through it. We've seen Edward the First and New Jersey Fire statute. And we know Edward the First was the authority governing from the 12th century to the present. But as a result of that missing history, we have lost the right in our interest to the land as a result of not realizing what went on this land. Okay, before those British monarchs got there, because it said the property of the British could not be confiscated because it actually belonged to the crown. Didn't it say that? British property found in the United States on this land at the commencement of hostile with Great Britain cannot be condemned as enemy's property. That means the United States or the states or the colonies cannot take the property that belonged to the English crown when it was being or overseen by what we call Great Britain. Okay, from 1707 to 1714. Okay, and then 1783, because 1783 we had the Treaty of Paris. Okay, when everything that the British monarchs had and the German monarchs had was surrendered to what they call the 13 colonies. Okay, so we're going to start right there. We're going to start right there. Treaty of Paris. Not overlooking Edward the First. All right, because we know Edward the First controlled these lands, not just New Jersey, but the whole continent was governed under the Plantagenet crown, and Edward the First was a king of the Plantagenet crown. Okay, he was son of Henry III. Okay, and when you get to the son of Henry III, you get into the Treaty of Paris of 1259. We're in the Treaty of Paris of 1783. We're going to trace this all the way back to the Treaty of Paris of 1259, and it's going to start with Henry III, who was the father of Edward I, who we find in the New Jersey Revised Statute in 2024. Did everyone understand what I just said? Please state yes in the comment box. We find Edward I in the 2024 statute. We're going to trace his ancestors all the way back to 1259 with the Treaty of Paris. And we got three treaties of Paris to be concerned with. All right. Three Treaty of Paris to be concerned with, going from 1259 to 1783. And Edward I is in the modern day statute in 2024. Do everyone understand that? Please type yes in the chat box. Okay. Treaty of Paris. The Treaty of Paris, signed in Paris and representative of King George III of Great Britain and representative of the United States on September 3rd, 1783. All I see is one yes, and that's by Mr. McGarrett. What's going on? Y'all falling asleep? Come on now. Y'all supposed to be like this. Let's go. Treaty of Paris signed by Paris by representative of King George III of Great Britain and representative of the United States on September 3rd, 1783, officially ended the American Revolutionary War and recognized the 13 colonies which had been part of the colonial British America to be free and sovereign and independent states. Okay? The Treaty of Paris of 1783, which was ratified on my birthday, January 14th, 1784. Okay, I was born on January 14th. Okay, I was born on January 14th. So ratification day was a ratification of the Treaty of Paris of 1783. Okay, and we're going to trace the Treaty of Paris from 1783 and 1784 all the way back to the Treaty of Paris of 1259. Okay, so that means that all the treaties that came afterward are irrelevant because we find Edward I in the New Jersey statute. So that means that all the statutes going back to him until the present are all we need. Any other treaty made outside of that are irrelevant because it shows the internal government being preserved based upon a treaty of peace and not a treaty of war. Because when there's war, the property can be confiscated, but when there's peace, it must be returned, as we've seen in Brown versus United States. Right, a time delay. Ratification Day in the United States is the anniversary of the congressional proclamation of the ratification of the Treaty of Paris on January 14, 1784, at the Maryland State House in Indianapolis, Maryland, by the Confederation Congress, which marked the official end of the American Revolutionary War. So you had the ratification day of the Treaty of Paris that took place on January 14, 1784, in honor or in ceremony or commemorative of the Treaty of Paris in 1783. Everyone must understand that. And that was superseded by the Treaty of Paris of 1763. So let's look at the Treaty of Paris of 1763, since we just looked at the Treaty of Paris of 1783, because when King George III gave up the property, he left it as it was. He didn't take it with him. He left it because it didn't belong to him. All right? The United States, the colonies took what didn't belong to them. All right? They stated it in Title 4630B1. It's abandoned property. It didn't say it was their property. It said it was abandoned property. And when it's abandoned property, it has the right to return back to the crown, as it's stated in Brown versus United States. But ain't no crown because there ain't no king. And when there ain't no king, that means the property becomes abandoned. Okay? The property becomes abandoned. So in order for us to trace who really owns the property, we must trace the monarch back to time immemorial. And we trace the monarch from Edward I to his descendants, okay? And the way we can do that is through the Treaty of Paris from 1783, ratified 1784, January 14th, to the Treaty of Paris of 1763, all here on this here continent, now called North America, okay? Now called North America. When the Treaty of Paris was established on September 3rd, 1783, that was what who? Great Britain and America. Okay? But what about the Treaty of Paris of 1763? That was with France and America. Okay? So let's look at that. Treaty of Paris of 1763. Let's walk down these treaties. Treaty of Paris of 1763, also known as the Treaty of 1763, was signed on February 10th, 1763 by the Kingdom of Great Britain, France, and Spain, with Portugal in agreement following Great Britain and Prussia victory over France and Spain during the 7-Year War. So you had the Treaty of Paris of 1783, ratified in 1784, January 14th. Then you had the Treaty of Paris of 1763 involving Great Britain, France, and Spain. Because France and Spain were governing territories over here, but they're were ruling or soon to be ruling overseas. This is why they were called overseas territories, okay? Or what they call crown dependencies. That's what they were called, okay? So we're talking about territory over here before Great Britain got here, okay? Before Great Britain got here, France and Spain were already here, okay? We know Great Britain started in 1707, okay? And England was already in conflict with France and Spain over here. But majority of you don't know that, so let's look at it. Treaty of Paris, also known as the Treaty of 1763, was signed on the February 10th, 1763 by the Kingdom of Great Britain, France, and Spain, with Portugal in agreement following the Great Britain and Prussia victory over France, Spain during the 7-Year War. You can look on the map, see the vast territory that this treaty encompass. Okay? Look at it. Great Britain, Prussia, Portugal, with its allies, France, Spain, Austria, Russia, with its allies. Okay? Very, very, very important. The signing of the treaty formally ended the conflict between France and Great Britain over control of North America, the 7-Year Wars known as the French and Indian Wars in the United States. It marked the beginning of an era of British dominance outside of Europe. Great Britain and France each returned much of the territory that they had captured during war. You hear that? They returned the territory that they had captured during war, but Great Britain gained much of France's possession of North America. Well said, Brother McGowan, Professor McGowan. So we see that in times of war, land is confiscated. In times of peace, wars land is returned or property returned. As we've seen in Brown versus United States, that the territory that the British Crown had under Great Britain in 1707 was returned. But returned to who is the question. Okay? Returned to who is the question. So it says Great Britain and France each returned much of the territory that they had captured during the war, but the Great Britain gained much of France's possessions in North America. So France had possessions in North America. You hear that? France had possessions in North America before Great Britain had it. And look at the territory that France had. It's all green. The territory that encompassed by Great Britain is blue. All right? We must comprehend that the French were in alliance with England before Great Britain even came into the picture. Okay? Spain had alliance with England before Great Britain even came into the picture by way of marriage into the Spanish and the French empires, okay, or dynasties. We must understand that. Apparently, much of you don't, so let's review that real quick. All right, let's review that real quick. We had the Treaty of Paris of 1763, superseded by the Treaty of Paris of 1783, ratified in 1784. All right, and they were both or all preceded by the Treaty of Paris of 1259. Okay, going back to who? Henry III. Okay, the father of Edward I, the father of Edward II, the father of Edward III. Okay, we must understand what's going on. All right, let's look at it. So Treaty of Paris of 1259. Let's look at that. The first Paris treaty, which we rely on. Other treaties of Paris are irrelevant if we don't consider this one, because this was the one that preserved the land by our ancestor Henry III, the father of Edward I, who we find in a modern-day statue in New Jersey in 2024. 2024. The 1259 Treaty of Paris, also known as the Treaty of Abbeville, was a peace treaty agreed between King Louis IX of France and King Henry III of England on the 4th of December 1259, briefly ending a century-long conflict between the Capitan and the Plantagenet dynasty. This is called the 100-Year War. This is called the 100-Year War. Did y'all hear me? The 100-Year War. How many of you know about the 100-Year War? Before we get into the 100-Year War, going back to the Treaty of Paris of 1259, first let's look at the empires who were ruling over here before the British Empire even started. Let's look at what we call New Spain and New France. Let's look at New France, okay, here in North America. New France was a territory colonized by France in North America, beginning with explorations of the Gulf of St. Lawrence by Jacques Cartier in 1534, ending with the secession of New France to Great Britain and Spain in 1763 under the Treaty of Paris, which we just talked about. Okay? So that's New France. I'm not going to get too much into it. You can get into your own. But we know that the territory governed by New France was governed by the French kings, okay, here in North America, all right? Before Great Britain even got here, before the British even got here, the French were here already, which were allied with the English known as the Anglo-Saxons, i.e. the Berbers. So we looked at the French Empire. Let's look at the Spanish Empire known as New Spain, okay, over here. New Spain. New Spain. Originally, the Kingdom of New Spain was an integral territory entity of the Spanish Empire. Okay? New Spain was an integral territory entity of the Spanish Empire established by the Habsburgs of Spain. It was one of the several domains established during the Spanish conquest in America. So you had the French conquest and the Spanish conquest here in America before the British even got here. Can everyone agree with me? If you can agree with me, give me a thumbs up in the chat. Okay? You had the Treaty of Paris of 1784, 1780, you had the ratification of the Treaty of Paris of 1784, which resulted from the Treaty of Paris of 1783, which came from the Treaty of Paris of 1763, which resulted from the Treaty of Paris of 1259, which was started by Henry III, the father of Edward I. Okay? Everyone agree with me? Please give me a thumbs up in the comment. Please give me a thumbs up in the comment. We know that before Great Britain was here, before Great Britain was here, there was New Spain and New France under the Spanish Empire and the French Empire. We just reviewed the French Empire. Now we're talking about the Spanish Empire. I don't see those thumbs up going up. Let's go. New Spain. Originally, the Kingdom of New Spain was an integral territory entity of the Spanish Empire established by the Habsburgs of Spain. It was one of the several domains established during the Spanish conquest of America and had its capital in Mexico City. Okay? Its jurisdiction comprised of large areas of southern and western portion of North America, mainly what became Mexico and the southwestern United States, but also California, Florida, Louisiana, Central America, and the Caribbean, and northern part of South America. Several Pacific archipelagos, including Philippines and Guam, additional Asian colonies, including Spanish Formosa on the island of Taiwan. So we see that all these territories that we're talking about here were all part of what we call New Spain. You can see it, New Spain. You see New France and New Spain. Okay? Once again, New France and New Spain were occupying territories over here in North America way before Great Britain even got here. All right? We must comprehend that. And those empires, New France and New Spain, were in alliance with the English and the French, which is a result of the alliance between the French kings and the English kings that were aligned with the Plantagenet kings as a result of marriage. Okay? Marriage. Now let's show you how New Spain and New France here in North America was a result of marriages between the queens of Spain and France who were married to who? What? Plantagenet kings. Once again, New Spain and New France here in North America resulted from marriages between Spanish queens and English kings. Okay? English and French kings, which are descended down from the Plantagenet kings. Okay? One was called Eleanor of Castile, and the other one was called Eleanor of Aquitaine. Once again, one queen was called Eleanor of Castile, and the other king was called Eleanor of Aquitaine. And they were married to Plantagenet kings who were ruling over here in North America. All right? One is called Edward the First, and the other one was called John. John was married to Eleanor of Aquitaine, and Edward the First, I think it was Edward the Third, was married to Eleanor of Castile. Let's see. I don't want to quote. Let's just see. All right. So we just reviewed New Spain and New France. And we know that New Spain and New France here in North America resulted from alliances that resulted from marriages between empires, queens of other empires that aligned themselves with kings of English and French empires. Okay. Let's look at the record. Eleanor of Aquitaine. Yeah, Eleanor Aquitaine, French king, she was married to King Henry II. King Henry II was the son of Godfrey, the fifth Count of Anjou, son of Fulk, a ruler of Jerusalem, which my family descend down from. King Henry II was the son of John, and John was the father of Henry III, the father of Edward I, who was married to what? Eleanor of Castile. So Eleanor Aquitaine of the French Empire were married into the Plantagenet king, King Henry II, son of Godfrey the fifth Count of Anjou, son of Fulk, who were ruling over here in what we call North America. Eleanor Aquitaine 1124 to 1204 was Duchess of Aquitaine from 1137 to 1204. Queen of France from 1137 to 1152 as his wife King Louis VII. And Queen of England from 1154 to 1189 as the wife of King Henry II as the heiress of the House of Poitiers, which controlled much of the southwestern France. She was one of the wealthiest and most powerful women in the Western Europe during the High Middle Ages. Okay? She was married to Henry II, all right, of the Plantagenet crown. She was married to Henry II under the Plantagenet crown. You're right, a little alliance. All right, Brother McGarrell. Go ahead, study, brother. Let's see. Spouse, Henry II. All right. Henry II was the son of Godfrey, the fifth Count of Anjou, son of Fulk. So we see that Eleanor from a queen of France, which is where the territory of New France come from here in North America. All right. That's where that territory originated from. All right. We're going to prove it through Nepal. Okay. King Napoleon. All right. King Napoleon originated with the Louisiana Purchase when in 1762, which we're going to talk about in a second. Okay, very important. So we got Queen Eleanor of Aquitaine, who was a French queen, and Eleanor of Castile, who was the daughter of Ferdinand. Okay, king of Castile. Let's see. Eleanor of Castile. Eleanor of Castile was Queen of England as the first wife of who? Edward I. She was educated at the Castilian court and also ruled the Countess of Ponthieu in her own right. After diplomatic efforts to secure her marriage and affirm English sovereignty over Gascony, 30-year-old Eleanor was married to Edward at the monastery of Las Huguelas Burgos on 1st November 1254. She believed to have birthed a child not long after. Okay? And we know Edward I, we find him here in New Jersey revised statutes. Okay? We find him in New Jersey revised statute. So we must understand or see the connection here. All right? So we see Eleanor of Aquitaine was married to who? Henry II, and Eleanor of Castile was married to Edward I. Okay? These were queens of Spain and France. Okay? Very, 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 very important. All right. So let's go to the Treaty of Paris of 1259. So we already went to the treaties from 1784, 1783, and 1763. Let's go to the Treaty of Paris of 1259 again, real quick. The 1259 Treaty of Paris, also known as the Treaty of Abbeville, was a peace treaty and agreed between King Louis IX of France and King Henry III of England on the 4th of December 1259, briefly ending a century-long conflict between the Capitan and Plantagenet dynasty. So that means that there was an end of the conflict between the Capitan and Plantagenet, which was called the 100-Year War. Once again, it was called the 100-Year War. Let's look at it real quick. The first 100-Year War. The first 100-Year War from 1159 to 1259. We had the Treaty of Paris of 1259, was a series of conflicts in the High Middle Ages during which the House of Capet, rulers of the Kingdom of France, fought the House of Plantagenet. You hear that? Fought the House of Plantagenet, also known as the House of Anjou, or the Angevins, rulers of the Kingdom of England. The conflict emerged over the Plantagenet-held Angevin Empire, formed by Henry II of England, the son of Godfrey V, Count of Anjou, which at its peak covered around half of the territory within France. The ongoing conflict between the two dynasties resulted in a gradual reconquest of most of their kingdom by the Capetans, and later the Plantagenets attempt to retake what they believed to be their rightful claim in Western France. So they were resulting in the 100-Year War, which resulted in what they call the Capitan victory. Okay? Don't forget this word, Capitan victory. Why is that important? Let's go to the Louisiana Purchase. As I come to my closing. Louisiana Purchase. The Louisiana Purchase was a acquisition. You hear that? Land acquisition. The transfer of land through acquisition of sovereignty. Somebody claimed to be the sovereign, but it has not been attested. Okay? Louisiana Purchase was the acquisition of territorial Louisiana by the United States from the French First Republic in 1803. What happened? 1 second. In 1803. Very, 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 very important. Listen, y'all. The Kingdom of France had controlled the Louisiana territory from 1682 until it was ceded to Spain in 1762. So we already went over New Spain and we already went over New France. We know both of them was a result of marriages between alliances between queens of France and Spain and kings of France and England, which were the Plantagenet kings who were overseeing the Kingdom of England as a result of marriages. Okay, and we understand that the Louisiana Purchases, which was the result of the Louisiana Purchase in 1763 because it was ceded in 1762 and it was ceded to Spain. So it says the Kingdom of France had controlled Louisiana territory from 1682 until it was ceded to Spain in 1762. In 1800, Napoleon Bonaparte, the first consul of the French Republic, regained ownership of Louisiana in exchange for territories in Tuscany as part of a broader effort to reestablish a French colonial empire. This territory later fell under the Treaty of Paris with Thomas Jefferson. Okay? It says right here, however, France failed to suppress a revolt in St. Dominica, coupled with prospects of renewed warfare with the United Kingdom, prompt Napoleon to consider selling Louisiana to the United States. Acquisition of Louisiana was a long-term goal of President Thomas Jefferson, who was especially eager to gain control of crucial Mississippi River and ports of New Orleans. These are our territories which we come from. My family was raised in Mississippi. All right, Marion, what's it? Marion County and Drew, Mississippi. That's where my family comes from. We see Thomas Jefferson took part in the Louisiana Purchase, which was a result of the territory that French ceded to Spain in 1803. And we know those territories that Thomas Jefferson received based upon unlawful command actually belonged to the property of the English kings as a result of marriages of the Spanish and French queens who were married by way of alliances with the Plantagenet kings, Henry II and Edward I, which we read. Okay, we've seen it for ourselves. So we see that the Louisiana Purchase that Thomas Jefferson retrieved by way of a conveyance was done by way of what we call Napoleon Bonaparte. Okay, Napoleon Bonaparte. How many of you know about who Napoleon Bonaparte was? All right, let's look. Let's look. Very important. Because he's going to take you back to the Capetine dynasty. All right, he's going to take you back to the Capetine dynasty. Napoleon Bonaparte, later known as the renowned name Napoleon I, was a French military officer and statesman who rose to prominence during the French Revolution and led a series of successful campaigns across Europe during the French Revolutionary Wars from 1796 to 1850. Who was his successor? All right, I can care less about who he was. Who was his successor? Louis the what? What's that? 18th. Louis XVIII was successor of Napoleon Bonaparte the first. So who was Louis XVIII? Let's see this. All right, let's connect the dots. We're talking about territory over here in North America based upon the Louisiana Purchase, which goes back to the Treaty of Paris of 1763. But we already know there was a Treaty of Paris in 1259 between the Capetine Plantagenet dynasties over a yearly conflict that ended in 1259. Okay, but we see Louis the 18th, successor of Napoleon Bonaparte, over territory here in North America. All right. So who was Louis the 18th? What was his dynasty, or who did he descend down from? Let's see. What was his house? His house was from the House of Bourbons. Everybody see that, right? He was from the House of Bourbons. Why is this important? Let's see. House of Bourbons. Let's go to an enclosure. The House of Bourbons is a dynasty that originated in the Kingdom of France as a branch of who? The Capetine dynasty, the Royal House of France. Now we're going to go back to the Treaty of Paris of 1259. 1259. Treaty of Paris 1259 was with who? A treaty that ended with the Capetine dynasty and the Plantagenet dynasty. So if the treaty ended with peace, what the hell is Napoleon Bonaparte doing here in North America over territories that were controlled by Edward I of the Plantagenet dynasty, which goes back to the Treaty of Paris of 1259, which was created by his father, Henry III. Henry III was the father of who? King Edward I. Okay, so what is the problem? Somebody is lying to us. Okay, somebody is lying to us because we just read Brown versus University, United States, and just said that all the property that was under the British Crown cannot be confiscated because all property that's confiscated actually belongs to the Crown of England. It belongs to the Crown of England. It said this in 1814 case. All property in England captured belonged directly to the crown, and individuals can acquire a title thereto in no other manner than by a grant from the crown. So as you can see, based upon the statute created by Edward I and the New Jersey Fire statute, 46:3-5 and 46:3-15 was a reserve statute for the land for the intel heirs that has been stolen by those freeholders who got their estate from those who retrieved the land by way of common recovery, which was changing intel land into fee simple. Okay? Intel land into fee simple. And that is a result of the land they acquired from what they call Great Britain, which should not have been confiscated. It should have been given back to the true heirs, i.e., the citizens, i.e., the English people. And the reason why it had to be given back to the English people, because the English people forgot their history, their culture, and their culture is based upon their beliefs. Okay, and the beliefs that is based upon our culture, which is based upon the laws that our ancestors were preserved for us, is based upon that as preserved in the statute. Okay, so you must understand that you are an heir, and the state that you belongs to you as an heir was taken to you through long, drawn out, unlawful conflicts that should have been reserved a long time through the Treaty of Paris of 1259. They have been creating a state of war so that they can keep taking the land from you. But if you know this history like I'm giving you tonight, based upon the comprehension of the Treaty of Paris from 1259 to 1763 to 1783 to the ratification of January 14th, even Thomas Jefferson told you that if they ever find out, it will be doomsday. All right, and I'm gonna close on that. Let me see if I can find that right here. Congressional debate. Due to several winters of 1783 and 1784, delegates from only 7 of the 13 states were present in Congress. According to the Articles of Confederation and Perpetual Union, 9 states were required to enter a treaty. One faction believed that 7 states could ratify the treaty, arguing that they were merely ratifying, not entering it. Furthermore, it was unlikely that the required delegates could reach Indianapolis before the ratification date. Thomas Jefferson faction believed that a full 9 states were required to ratify the treaty and that any few would be trickery that Britain would eventually find out. Given an excuse to nullify the treaty, Jefferson stated that it would be a dishonorable prostitution of the great shield of the United States. Do you hear that? He knew what he was doing. Why? Because when they separated church and state, they separated the government of the church. And as a result of that, they separated the right of the primogeniture birthright for me as your king to come back. But thanks be to our ancestors who have reserved that practice by way of mental comprehension, which was reserved for us when that information has awakened, which was dormant in us. So please understand how important it is for you to have an interest in the state, i.e., an export interest. And the only way you can do that is to understand your birthright in its entirety. You are subjects of the crown of England. And as a result of you giving up your birthright, you are considered property of the state, abandoned property. And the only way you can retrieve your estate is return back to the crown by showing your allegiance to the crown, by honoring your king, by pledging your allegiance to your ancestors, going back to what we call time immemorial. So with that, make sure I covered everything. I think I did. Yeah, I did. Okay. So with that, we're gonna close out, and I just want to let every one of you know that there will be no more lectures being done. The only thing that will be done now, thus far, will be categorizing the lessons and put them in a format easy for you to comprehend based upon the levels that you will be entering when the temple doors open. Okay. So for all of you who are here tonight, I suggest that the past 10 videos that I've done, please study them from the last one I did. Count back 10 videos and start there. And when you watch those videos, you are to give a brief perception and conception of that video in that comment box. And when that perception and conception is done in the comment box, I will get a alarming that you have done so. That means each and every one of you are to be raised in level by comprehending the videos of the past 10 videos that I've done. And the only way I know you're going to comprehend is by leaving a comment in the chat box and a briefly, lengthy statement of what you understand and what it is that the video pertains to. Okay. And as I said, the videos that are now going to be done is going to be broken up to groups for those who come to the class. But future notice there will be no more videos being done based upon information because you have enough to go on as of right now. So with that, I thank you all for showing up today, and I'm going to greet you and meet as I always meet you, and as always in peace and love. Archbishop, if you're watching, please put the template in for this actual video. And all, as always, your free and common focus is always needed. You can send your donations to $ Clifford Jefferson L or the Third Temple English Church of England, as well as follow the requirements as set forth by Archbishop Belmont, so that when that day comes, you'll be counted amongst the righteous. With that, I say